For our case, we have the United States Court of Appeals for the Sixth Circuit in the case of Dashuna Richards and Eddie Harris versus the city of Jackson, Michigan, and Matthew Peters, who is a police officer. This case actually denies qualified immunity to a police officer. In this case, a police officer went into a home and shot a non-aggressive dog. The Court of Appeals is addressing the issue of qualified immunity and decides that it is not qualified immunity under the circumstances of this case. So let's read it and see what the court had to say about this and see that cops do occasionally skirt past the qualified immunity doctrine. It is undisputed that Officer Matthew Peters had no warrant, exigent circumstances, or consent to enter the residences of plaintiff Dashuna Richards and Eddie Harris on November the 28th, 2014. But when Peters approached the front door, which Peter claims he believed would lead to a common area, even though the plaintiff's door was clearly marked with an individual house number and had its own mailbox and doorbell, he opened it without knocking and walked inside. Once inside, Peters announced his presence, which prompted the plaintiff's pet dog, Kane, to run down the stairs and growl at the officer who was inside the home. Harris testified that although Kane was well-trained and did not bite or lunge at the officers, Peters shot Kane as soon as the dog reached the bottom of the staircase. Richard and Harris brought this cause of action against Peters, alleging that he unlawfully entered the home and shot their dog in violation of the Fourth Amendment and Michigan state law. Peters moved for summary judgment on the ground of qualified immunity and Michigan governmental immunity, and the district court denied the motion as to plaintiff's Fourth Amendment claims and state law claims of conversion and gross negligence, and we affirm. In 2014, Dashuna Richards, Eddie Harris, and their pet dog, Kane Lee Cheney, known as Kane, his dog with 3 names, lived together at 513 South Blackstone Street in Jackson, Michigan. Richard bought Kane in 2009, and Richard and Harris shared responsibility for Kane over the 5 years that follows. Harris trained Kane, and Richard fed and cared for him. Richard and Harris described Kane as a well-trained American Pit Bull Terrier who had never displayed aggression towards other animals or people. On November the 28th, 2014, 2 police officers arrived at the address for reasons unrelated. On November the 20th, 2014, a probate judge had ordered a man named Dante Cox to report to the Alliance Health Hospital as he failed to pick up his prescribed medication. I'm assuming here that the individual named here had an order to take medication for some sort of court order. So, obviously normally picking up medication is not a violation of law. I'm assuming that this guy was under court order for psychiatric medication or something similar to that. If Cox did not appear at Alliance Health, the order stated that police officers would take Cox into protective custody and transport him to the hospital. When Cox failed to appear, the Jackson Police Department dispatched the officers to look for Cox at several addresses in Jackson, including at 511 and 513. Cox did not live at 513 Blackstone in 2014, and it's unclear from the record whether he had ever lived at that address. The officers began looking for Cox at the addresses provided by dispatch, which led them to the plaintiff's address. Upon arriving at the address, the officers found the 2 units were part of the same building. Each unit had a separate door on the exterior of the house, and each door was conspicuously labeled with a single distinct address identifying the residents inside. Each door was also accompanied by its own mailbox, and the door marked 513 had its own doorbell as well. One officer went to the door labeled 511, and the other officer went to 513. The officer knocked at 511, waited, and did not receive a response, so he did not enter. The other officer, in contrast, approached the door at 513 and walked inside without knocking or ringing the doorbell. Peters admitted that he had no search warrant, no consent, and no exigent circumstances that would have permitted him to enter the home. But Peters contends the front door was slightly ajar, and there was no solid door behind the screen door, so he presumed the door led to a common front entrance for multiple apartments, despite acknowledging that only one house number was listed on the door. In contrast, Richards and Harris testified the door was not a common entry. Instead, they contend Peters walked through the front door of their home, a door that did not provide entry to any other unit except theirs, as indicated by the address marked on the doorway. Both the testimony and multiple photographs of the property contradicted the officer's description of the door. There are actually 2 doorways at the entranceway, the screen door that Peters described, as well as a second solid white door immediately behind the screen door. Harris maintains the screen door was closed before Peters entered the home and heard the screen door creak open upon entry. The audio recordings from Peters' body cam microphone captures the sound consistent with the creaking that was described. Upon entering the doorway, Peters saw a small foyer, a flight of stairs, and an additional door on top of the stairs. The door at the top of the stairs opens into Richards and Harris's living room, where Harris was playing a video game with Richards' younger brother. Kane was lying nearby. When Harris and Caldwell were playing video games, they heard the screen door creep open and heard footsteps in the doorway, alerting them that someone was inside the home. Standing inside the foyer, Peters knocked in the interior wall of the apartment. After the knock, the audio recording from Peters' body microphone captures Harris yelling from the living room, "Who is this?" Peters responds, "Police." Right after Harris yells and Peters responds, the audio recording captures the sound of Kane running and growling for 4 seconds. Peter then contends that he said, "Get your dog," but Harris contends he could not hear Peters say anything. The audio recording captures Peters saying something dog, but the recording makes it difficult to discern the full quote or how loudly Peters was speaking. Kane continues to make noise, though it's unclear whether the sound is running, growling, or some combination of the two. Within 2 seconds of Peters saying something dog, the audio recording captures him shooting and killing Kane. What the audio recording does not capture, and what is hotly contested, is whether Kane, Harris, and Peters were doing in the 6 seconds between the time Kane began running from the living room and the time which you saw it. Both Harris and Peters agree Kane ran down the stairs and growled, but from there, the witnesses to the shooting provide differing stories. Harris testifies that Kane began running down the stairs to prevent Peters from coming up the stairway because Peters was trying to creep in and creep upstairs without saying nothing. At the time Peters shot Kane, Harris contends that he was going down the stairs to get his dog, but Peters fired the shots before he could reach Kane. Harris testified that Peters shot Kane as soon as Kane got to the bottom of the stairway. In contrast, the police officer wrote in his police report that Kane immediately ran down the stairs, came directly to his feet, and began growling, snarling, and biting at his feet and ankles. Peters wrote that he yelled for someone to get the dog and kicked it, but one kick set the dog back against the bottom of the stairs only to have it charge back and again biting his leg. Presumably, there would be some bite marks on his leg. There would be some medical testimony of evidence of these bite marks, right? He's saying he's bit and scratched them, so surely there's going to be a medical report that's going to back this up, I'm sure, right? Let's wait to see where the medical report is of the bite marks on the leg. I mean, we're going to see that, right? I'm sure we are. Peters later testified he did not try to exit the apartment during the encounter. And while he's sure at some point he could have exited the apartment, he did not feel he had time to exit after yelling for someone to get the dog. Peters contends that after he yelled, Harris appeared at the top of stairways, ran a third of the way downstairs, and started yelling at Peters, though the audio recording does not capture it yelling. Peters testified that Kane returned between Peters' legs a second time after being kicked and shot Kane at that point because he believed Kane was going to bite him. Costly, the officer who was initially positioned outside 511, entered the plaintiff's residence after hearing Peters' voice coming from inside the unit. The police report states that at the time he entered, Peters was backed into the far corner of the small foyer area, and Kane was at his legs growling and barking in a vicious manner. Costly wrote that Peters attempted to push the dog away with his foot, and Kane moved back but immediately began advancing towards Peters again, while continuing to grow and bark aggressively. The record is also unclear about the size of the foyer and Peters' location at the time of the shooting. The foyer is located between the front door and the stairwell that leads to the living room, but none of the witnesses or testimony or photographs in the record provide a clear estimate of the dimensions, and the officer's account regarding Peters' location within the foyer differ. Peters repeatedly states in his deposition he was standing just inside the door, but Costly testified that when he entered the plaintiff's home through the same door, he was backed into a corner. What's it with cops and slightly ajar front doors? Well, I think it might be possible. I'm just saying, guys. But bear with me. Come in close. I think it might be possible that cops occasionally fudge the truth a little bit. I think that might be a thing. Just saying. After the shooting, the audio recording captures Harris saying, "Why you shoot my dog, man?" Peters says, "Because he's biting me." Again, we're going to see medical testimony. We're going to see the dog dribble. We're going to see the closed torn. We're going to see the bite marks. We're going to see the ER report, right? That's going to come up any second to validate this testimony, right? But when deposed, Peters admit that Kane never bit him. Oh man. Oh, the cop kind of may misrepresent the facts a little bit. Wow. I can't believe it. There he testified Kane was biting him, but did not make physical contact with his leg. Oh, well, I guess that explains why we didn't see that medical report after all. Harris also contends that Peters was flippant and even laughed during their conversation after the shooting. The Peters testified that he did not recall having laughed. Personally, I believe the cops probably laughed. On September 29, 2016, Richard and Harris brought a cause of action against Peters, alleging Peters unreasonably searched their home and seized Kane in violation of the Fourth Amendment and Michigan tort law. Peters moved for summary judgment on grounds of qualified immunity and Michigan governmental immunity. On August 27, 2018, the district court denied the motion for conversion and gross negligence claims. Peters finally a notice of appeal. So conversion is the civil equivalent of theft. Basically means you've taken property without permission. That's the civil term for it. What gets me is cops will tell you police dog biting a suspect is not that big a deal, and yet they have to shoot dog if it comes too close. Yeah, that's that's pretty astute observation there. It's not a big deal when the trained police dog does it, but if the owner's dog does it, hugest deal ever. Yep, there might be there it might be guys. Again, I've come in real close. It might be that the cops don't necessarily always apply the rules to themselves. Just In analyzing whether an official is entitled to qualified immunity, we must make two determinations. First, where the plaintiff have created a genuine dispute of material fact regarding the official deprived them of a constitutional right, and second, where the right was clearly established that such a reasonable official would have known his actions were unconstitutional. Courts can address these in any order. In undertaking the inquiry, we accept the view most favorable to the facts of the plaintiff for the purpose of appeal. Here, the district court denied the qualified immunity for the two Fourth Amendment claims. First, the claim of warrantless entries in the home constituted an unreasonable search. And second, the claim that shooting and killing the dog constituted unreasonable seizure. We address these each in turn. In determining whether the district court erred in denying the officer qualified immunity for entering the home, we begin with the question of whether the plaintiffs have presented a genuine dispute of material fact regarding whether the entry into the home deprived them of a Fourth Amendment right, and then analyze whether that right at issue was clearly established. Well, let's see. Is there a clearly established right that to prevent the police from entering your home with no warrant, no exigent circumstances? I'm going to have to say yes. I seem to remember reading that right once. I seem to remember that it was, I don't know, Amendment 4 of the U.S. Constitution comes to mind. That seems to be pretty well previously established, just off the top of my head. The Fourth Amendment protects against unreasonable searches of an individual's home. The Supreme Court has recognized physical entry of a home is the chief evil against the wording of the Fourth Amendment is directed. In terms that apply equal to seizure property and seizure persons, the Fourth Amendment has drawn a firm line at the entrance of the house. The home is special. The Supreme Court has taken this threshold seriously, making clear that any physical invasion of the home by even a fraction of an inch is too much, and there's certainly no exception to the warrant requirement for the officer who barely cracks open the front door and sees nothing but the non-intimate rug on the vestibule floor. So in other words, the very moment that you open the door with the creaking noise, you violate the Fourth Amendment. Amazing concepts at work. Peters does not argue that he had a warrant, consent, or exigent circumstances. Instead, his argument turns on whether he had entered the plaintiff's home at all. Really? Really? It's pretty clear he did. I mean, okay. Pierce claims he reasonably believed the front door led to a common entryway shared by multiple residences, and he argues that individuals have no exceptional, objectively reasonable expectation of privacy in an unlocked and common hallway entrance and stair of their duplex. I mean, I would argue they do. They have a shared interest in it with the other people of the duplex, but still, even the shared entryway belongs to both them collectively. It's not the police's. I mean, by that argument, any random person could come into the shared area of a duplex and it would be okay, which doesn't even begin to make sense in my mind. Pierce's position elucidates a critical factual dispute where the foyer was in fact a common area. The plaintiffs vigorously dispute the foyer was a common area, and the record supports it. The district court rejected the suggestion that it was a common area, finding each unit had its own door and plaintiffs were the only residents of the building who had access to it. We agree the plaintiffs have demonstrated that they entered the home and not a common area. The remaining argument is that even if he entered the home, he had restricted his movement to the area of the apartment that was generally accessible to visitors of the property is unpersuasive. Yes, it's generally accessible to visitors who are invited. Who are invited. If I am, like, for example, a door-to-door salesman going door to door, and I open the door and I walk into your foyer to say Avon calling, you're going to have a problem with that, as well you should. Richard's deposition makes clear that although the living room and bedroom were on the top of the second set of stairs, everything inside the door that Peters Beach is part of the apartment. Once Peter entered the plaintiff's home, it did not matter whether he was in the front hallway where they accepted visitors, again, who are invited, or in their bedroom. Any physical invasion of the structure of the home by even a fraction of an inch is too much. I agree. So under the argument, the cops could come anywhere I've invited someone in, it's no biggie. I guess so. I mean, that seems to be the implication. I mean, if you have an entryway of your home, and apparently the cops can come in there and presumably anyone else, right? Because you have no privacy interests in the foyer of your home, because lots of people come in the foyer of your home. I don't know what to tell you. The argument's wrong. I grasping at straws is all I got. Even assuming entry into the plaintiff's home was unconstitutional, Peters argues he reasonably believed the foyer was an entrance to the common area. An officer who acts on that mistaken but reasonable belief is entitled to qualified immunity. This court has held that a government employee will be shielded from liability so long as the employee acted under an objectively reasonable belief that his or her actions were lawful. Thus, at this stage of litigation, we must determine whether a jury could reasonably find the belief was not objectively reasonable. Peters contends that when he entered through the unlocked door in a multiple occupant building, he believed the door would lead to a foyer for which he could access the doors to multiple interior units. In his deposition, Peters testifies that in Jackson, there are countless large homes with multiple apartments inside of large buildings, mostly which you have to go to get inside the individual apartments, be it 1, 2, 3, A, B, or C, and in his experience, the address markings on these exteriors of buildings would not always indicate there are multiple units. But Peters also agreed he had received no information from dispatch indicating that such subunits existed in this apartment, and that he was not asked to look for an individual in 513 A, B, or C. He simply told Cox might be at 511 or 513, each of which had its own door and address marking on the exterior of the home. The fact that some houses in Jackson have this design does not preclude a jury from finding that Peters was unreasonable, assuming this house would have such a feature. Again, with the cops with the mistaken door, we're back to the Amber Geiger trial all over again, with the cops with the mistaken door, man. Lord. I guess this happens more than you would expect, or something. I wonder if this one also had a bright red floor mat. The photographs of the home's exterior further undermine the unreasonableness of the belief. The clear address markings, individual mailboxes, and doorbell outside the door cut against the idea the front door led to a common area. After considering all the evidence, the district court found that whether it was unreasonable for the officer to assume plaintiff's home consisted of multiple dwelling units and he unlawfully entered the home presents a genuine issue of material fact, which should be determined by the fact finder. We agree. Because there is a genuine dispute, a material fact regarding whether the officer's belief that he did not enter the plaintiff's home when he walked through a doorway was reasonable, we affirm the denial of qualified immunity. Yeah, you go to a jury and you try to convince them it was reasonable. Good luck with that. Let us know how it turns out. In determining whether the district court erred in denying the qualified immunity for shooting Kane, we begin with the question of whether the right was clearly established on the 28th of November of 2014, and the address of whether the plaintiffs had a genuine issue of material fact regarding whether the officer seized Kane in violation of the Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures of an individual's property. The court has acknowledged that there's a constitutional right under the Fourth Amendment to not have one's dog unreasonably seized. In deciding the contours of that right, we began with the premise that a seizure becomes unlawful when it's more intrusive than necessary. In determining whether a seizure of a dog was more intrusive than necessary, we reiterated the holding that court must balance the nature and quality of the intrusion of the individual's Fourth Amendment interest against the importance of the governmental interest alleged to justify the intrusion and determine whether the totality of the circumstances justifies the seizure. Yeah, Evil Coastal, I think you're right. I think you're right where there's no knock warrant and went in the wrong house and killed someone. I think you're right. I think that's exactly right. I think it's true. I'm now depressed. Fantastic. Well, it didn't help that we were reading the shooting the dog story, so depression was pretty much guaranteed. Let's carry on. In Brown, we conclude that shooting a pet dog is a severe intrusion given the emotional attachment. But we also found that ensuring officer safety is particularly important governmental interest. After balancing these interests, we found that police officers' use of deadly force against a dog while executing a warrant to search a home for illegal drug activity is reasonable under the Fourth Amendment when, given the totality of the circumstances and viewed from the perspective of an objectively reasonable officer, the dog poses an imminent threat to the officer's safety. We define the requisite imminent threat as an immediate, real threat to one's safety that justifies the use of force in self-defense, or the danger resulting from immediate threatened injury sufficient to cause a reasonably and prudent person to defend him or herself. In defining the right at issue, we note that a large number of our sister circuits have already concluded that the use of deadly force against a household pet is reasonable only if the pet poses an imminent danger and the use of force is unavoidable, and that every circuit to consider the issue has concluded that the unreasonable killing of a dog constitutes an unconstitutional seizure. Accordingly, we determined the right not to have one's dog unreasonably seized was clearly established, and we proceed to determine whether the seizure at hand was reasonable, and we see no reason to depart from that here. Despite this court's holding in Brown, Peters argues the right issue was not clearly established, neither of which is convincing. First, the officer argues that Brown was issued in 2016, which is later in time than the conduct issued and therefore cannot suffice. This argument misreads the case, which we unequivocally stated that the constitutional right under the Fourth Amendment not to have a dog unreasonably seized was clearly established in 2013. So yes, they're citing in 2016 that says it was established in 2013. So yeah, because the right was clearly established in 2013, it was also clearly established in 2014. Yeah, of course. Second, Peters argues that he could not have been expected to anticipate our recognition of the case that unlicensed dogs are property under the Fourth Amendment. Really? You couldn't be expected to understand dogs are property? Okay. How the officers argued they shot Kane because he believed Kane was unlicensed and that they had no property interest in an unlicensed dog, this argument might have some force. But Peters gave no indication that he knew or even considered when Kane was unlicensed at the time of the shooting. Thus, the officer's ability to anticipate this court's ruling in Smith has no bearing on whether Peters should have known that his actions were unconstitutional. We must next determine whether the plaintiffs have raised a genuine dispute of material fact regarding whether Kane presented an imminent threat that justified the decision. At this stage of the case, we're required to view the facts in the light most favorable to the plaintiffs, even where only a genuine dispute is created by the plaintiff's uncorroborated testimony. Thus, for the purposes of appeal, we must assume that when Peters announced his presence from inside the home, Kane ran down the stairs and growled but never advanced past the foot of the stairwell. That Kane did not lunge or bite at Peters, and Harris was on his way down the stairs to get Kane at the type shot. So yeah, on the motion to dismiss, we assume the facts in light of the non-moving party. So we're assuming that the people are right and all the things they say are true. Of course, we'll have to prove that at trial, but we're assuming it's correct in order to get to the motion to dismiss. If everything they say is true, they have a case. All right. We begin our analysis of whether a seizure in this case was reasonable with a closer look at Brown. The specific facts in Brown led this court to conclude that no genuine dispute of material fact existed regarding the reasonableness of shooting two dogs. In Brown, officers were executing a raid on the home of a suspect who posed a serious threat to officer safety. Officers knew the suspect had a criminal history, used firearms, and had deep ties to a large, tightly knit gang. These circumstances placed the officers in Brown on a high alert going into the raid that other members of the gang could be in the residence and they could be armed and dangerous. In Brown, it was also undisputed that dogs displayed some sign of aggression beyond growling. The dogs began lunging towards the windows as officers approached the front door. The 97 dog jumped the couch and lunged at officers again as they entered the residence, which prompted the officers to fire at the dog. This is again talking about the prior case of Brown, not the current case. Still, the dogs continued to obstruct the official's path in the basement of the home. Given the high risk presented by the suspect's firearm and gang activity, the officers' priority in securing the basement and conduct for a sweep for other potentially dangerous people in the home, the officers testified they could not safely accomplish this goal with both dogs being present. Despite having been shot once, the 97-pound dog turned the officers in the basement and started barking again, so another officer fired a round of shots, killing the dog. The 53-pound dog was also in the middle of the basement, barking at officers as they attempted to clean the area. The same officer who just shot the second dog when he saw it barking at the officers, and the second officer fired at the dog again when it began moving towards him. In determining that shooting the dogs was not unreasonable, in the prior case, we emphasized that those plaintiffs, in that case Brown, failed to rebut several undisputed material facts, namely that the large dog had lunged at the officer before they shot. The officers weren't able to safely clear the basement with both dogs there. The court also reiterated the suspect criminal's history and gang affiliations, the fact the officers had no time to plan for the dogs, the nature and size of the dogs, and the fact that dogs were unleashed and loose in a small residence. Considering each of these factors as part of the totality of the circumstances, we found the plaintiffs failed to create a genuine dispute, a material fact regarding whether the dog was barking and lunging at the officers as they breached the entryway, posed such an imminent threat to the officers it was necessary to shoot the dog in order for them to safely sweep the residence and ensure that no dangerous people were present. The facts of Brown bear some similarity to the present case. Like in Brown, Peters did not know about the dog in advance and had no time to plan for how to handle the dog. Additionally, Kane was off the leash in what appeared to be a small area, but there are several meaningful differences. First, the level of aggression described in Brown is a common theme in cases where courts have found the seizure was reasonable. Taking the facts in the light most favorable to the plaintiff, Kane displayed a significantly lower level of aggression. Here, Peters' only reason to believe Kane presented an imminent threat was that he ran down the stairs and growled when an unknown person entered the home. As the district court noticed, this behavior is distinguishable from more serious displays of aggression akin to lighting or bunging because descending stairs, barking, and growling is naturally expected of a dog when a stranger enters a home. We do not hold today that a dog must bite an officer before he can fire a weapon, but a jury could reasonably find the absence of any aggression apart from growling is a factor that cuts towards unreasonableness in assessing the totality of the circumstances. Furthermore, the context of the seizure is dramatically different from that in Brown. Unlike the officers in Brown, Peters was dealing with only one dog, and here there was no intimation of high-risk gang activity or a similar level of threat inside the home that required Peters to conduct a sweep for safety of this home. rather than Peters had been dispatched to look for a man who failed to pick up medication. As discussed above, Peters did not even have a warrant to enter the home in question, let alone to conduct a thorough sweep of the premises. Relatedly, the questionable validity of the search distinguishes the case from Brown. Although the primary question in excessive force is typically whether the force used to effect the seizure was reasonable in the totality of the circumstances, not whether it was reasonable for the police to create those circumstances, this court has acknowledged that where the events preceding the shooting occurred in a close temporal proximity to the shooting, those events have been considered in analyzing whether excessive force was used. Because the audio recording suggests Peters' relevant conduct from the time he entered the home to the time he shot Kane, which occurred within 17 seconds, a jury could reasonably find that Peters unlawfully entered the preceding shooting the home as an additional factor cutting against reasonableness. Several additional unresolved facts suggest a genuine dispute of material fact remains. For example, the uncertainty in the record regarding the size of the foyer and the location in the foyer at the time of shooting makes it difficult to tell whether Kane posed an imminent threat. A jury could reasonably find that a growling dog standing several feet away from an officer does not present the same type of imminent threat as a dog who is lunging towards the officer. The record also contains no information about Kane's size. In Brown, this court looked to the nature and size of dogs, noting that the record demonstrated that the one dog was 97 pounds and the other dog was 53 pounds. In contrast, none of the police reports or depositions in the case even describe Kane as large or small. The lack of information about size matter, as a jury could reasonably find that a threat posed by a 30-pound dog is meaningfully less severe than one posed by 97 and 53-pound dogs. In light of all the considerations enumerated above, the lack of aggression beyond common dog behavior running downstairs and growling at strangers in the home, the absence of high-risk criminal activity, Peters' unlawful entry into the home, mysterious disputes in the record regarding the distance, and lack of any record facts regarding Kane's size or weight, we conclude the plaintiffs have a material dispute of fact. So that is the case of Dashuna Richard and Eddie Harris, and indirectly the dog Kane, versus Matthew Peters and the city of Jackson. So, lessons learned here: if you do not have a search warrant or exigent circumstances, you can, in fact, not enter someone's home. That is not an okay thing to do. And once inside their home, you cannot just shoot their dog for any reason that suits your fancy. So this is going to go back to trial, and the jury will have to determine whether or not the officer was mistaken and whether or not his actions were reasonable. So at least both parties will get their day in court, and a jury will have to decide what damages accrue as a result of this. So we keep a watch of this and see what happens next.